I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you aboard. Two big trials that we're covering. And there was video today shown to the jury down in Brunswick, Georgia, in the shooting death of Ahmaud Arbery murder trial that we haven't seen before. Video that was shot at the time Ahmaud Arbery was being chased and followed through the neighborhood. First time we're seeing it. So we're going to show that to you coming up this hour on this program. But we're going to begin tonight in Kenosha, Wisconsin, in the other big case. This is the case against Kyle Rittenhouse, accused of double murder, accused of shooting 3 men during the riots in the summer of 2020. Now, as you know, I'm a former prosecutor. And as a prosecutor, I'm looking at this case and I'm saying, what is going on here? I'm in bizarro world. Because generally speaking, prosecutors, we have one obligation, right? And it's to get to the truth, okay? The facts are what they are. We don't change the facts. We don't try to shade the facts. We present the facts. We argue the law. That is it, okay? That's our job. Our job is to get to the truth. And when I say our job, I mean prosecutors. It's a much different job than criminal defense attorneys have. Their obligation is to their client. They're the defendant in the courtroom. And this isn't a knock on criminal defense attorneys about, the relationship between defense attorneys and the truth and prosecutors and the truth. It's just what our ethical obligations are. Prosecutors seek justice, which is the truth. Defense attorneys represent your client's interests. Period. End of story. It's that simple. But what is happening in Kenosha right now? And I think it's a real problem because juries can smell this. Anytime you as a prosecutor have problems with the truth, whether it's you or the witnesses you're putting up on the stand, that is trouble with a capital T. You cannot afford it. And in this case, we've talked about it in the opening statement. The prosecutor painted this picture of Kyle Rittenhouse chasing Joseph Rosenbaum and shooting him in the back. And I had an image in my mind. And then I saw the video, and it was like the exact opposite of what was described by the prosecutor. Okay, it may be, he's going to piece it together at some point, but that's not what I saw in the video. Then the eyewitness to the shooting, Richard McGinnis, takes the stand, and the prosecutor is attacking the credibility of his eyewitness. The eyewitness is going to say what he saw. Right? The facts are the facts. Nothing you can do about it. Then today, Gaige Grosskreutz, the shooting victim who survived, took the stand for the prosecution. Should be the star witness. Should be the star witness. But there were more problems today. Like problems with him not telling the truth to police and saying one thing when we're looking at videos that show something else. It's unbelievable. And as I said, it is trouble with a capital T for prosecutors. Let me show you an example. Here is some of the cross-examination of Gaige Grosskreutz.
Toward the end of that large paragraph, you'd agree it says, sometime during the incident, my Gen 4 Glock 27 that had a belt clip attached fell off my waist, correct?
Correct.
Okay, that's a lie, right?
I wouldn't say that's a lie, no.
You didn't take the Glock out of your back here and run with it?
I did.
So it didn't fall off your waist, it was in your hand.
That's correct.
So you would say that's not a lie?
No, I would say it isn't.
Okay, and you told that to multiple officers, isn't that true?
I don't know.
The next sentence. I told multiple officers that I dropped my firearm, right?
Correct.
Okay. Now, you didn't drop your firearm. You were chasing Mr. Rittenhouse with your gun, right? Yes. You were chasing him with your gun? Yes?
No.
You didn't chase him down Sheridan Road, pulling your gun, chasing after him. That's a lie. You're saying that didn't happen?
I'm not saying that it didn't happen, but I wasn't chasing the defendant.
You were running after him?
No.
No. during this trial, you're tweeting out, yes?
Yes.
And you tweet out to whoever these people are, make sure you look and listen for the defendant's firearm malfunction, and then you have a winky emoji face. Is that right?
That is correct, yes.
And you had said that you were looking for a non-lethal way to end this interaction.
That is correct, yes.
Yet you pulled your gun out and began, I'm going to use the word chase. You began chasing or running after a man who was running away from you, correct?
That is correct.
Now, you had said, and you were asked about the do no harm and the tattoo on your arm and things like that, right? You have some regrets from that evening, don't you?
No.
That's a photo of you, yes?
Yes.
Okay. That's Mr. Rittenhouse?
Correct.
Okay. Now, you'd agree your firearm is pointed at Mr. Rittenhouse, correct?
Yes.
Okay. When you were standing 3 to 5 feet from him with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
Now, you had said you didn't have any regrets. Did you tell Mr. Marshall that your only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag into him?
No, I never said that.
You didn't tell that to your roommate.
Objection, answer.
Hold on.
You didn't tell that to Mr. Marshall?
No, I did not.
Let me bring in Court TV legal correspondent Chanley Painter joining us tonight from Kenosha, Wisconsin. Chanley, great to see you tonight. Again, I always do this from where I'm sitting, right, which is watching this and then sometimes rewinding and watching again. This didn't seem like it went that well for prosecutors today with one of your victims or alleged victims, complaining witnesses, whatever we're calling them in the courtroom, surviving shooting victim, testifying today.
Right. Immediately out of the gate, this cross-examination took over the courtroom. Sparks were flying. You could tell everyone sitting on the edge of their seats, even the jury, raising eyebrows, going, okay, this is important. I'm taking pen to paper and taking note of all of this. Really, in the years covering cases on Court TV, this cross-examination, Vinny, was dynamite sitting inside the courtroom. And this defense attorney doing a fantastic job. You could tell he was well prepared in trying to hold Gaige Grosskreutz feet to the fire, impeaching him on his police statement, his testimony today, and really scoring some huge points for the defense.
It was, and inside the courtroom, how does it work when you've got the witness and you've got the video going up at the same time? I mean, some of the things he said just seem to be the exact opposite of what we have seen. Does the jury look at both? Like, is the picture of him pointing the gun at him up while he's testifying about that? Is the video of him running, I guess, towards Kyle Rittenhouse? He's not saying he's chasing him. The jury will figure it out. But running in that, is all that being played for this jury at the time that he's saying, no, that's not happening?
This defense attorney is doing that. He allows the witness to first answer the way the witness wants to answer, and then he will put the picture or the video or the statement in front of the jury on 2 huge television screens and pause it at certain points, and then the witness would change his story and agree with the defense. And on recross, he did eventually agree and say that, yes, he was chasing Kyle Rittenhouse down the street, who was running the opposite direction, and he had a loaded gun with a bullet in the chamber. He did finally agree to that later on in the recross examination. But the moments that you say that the defense attorney was able to put on the screen, the still photos, it was powerful, especially the part where he paused the video to the picture where he gets Gaige Grosskreutz to admit that the position his body was in after he raises his arms to Kyle Rittenhouse, but then Kyle is on the ground, right the moment that Kyle shoots Gaige Grosskreutz, is your gun pointing at the defendant? And he agreed. And that was the moment you could really tell in the jury that, okay, and they wrote all of that down, Vinny.
Let's get some reaction from our think tank tonight. Stand by, Chanley. Joining us in Fort Lauderdale, Florida, criminal defense attorney and civil rights attorney Gaige Grosskreutz. In Atlanta, Georgia, criminal defense attorney and former president of the Georgia Association of Criminal Defense Lawyers, Lawrence Zimmerman. And also in Atlanta, criminal defense attorney Michael Bixson. Great to see everyone tonight. Gaige, tell me your thoughts about how this is going for prosecutors. And I'm a former prosecutor. I'm looking at it, I'm like, I would not feel good right now. And when I've got one of my shooting victim up on the stand and seemingly kind of not stating things that are obvious to me when I look at the video.
Not at all. This is zealous advocacy at its best. The defense attorney came in and he did his job. He went and attacked the credibility of what I would say would be the prosecution's star witness. And what baffled me from the beginning was, why did the prosecution bring out the bad facts? I actually fell in love with the witness. He was credible on direct examination, and then they just attacked what was obvious to the prosecution. Why not bring out the complaint? Why not provide an explanation? You cannot rehabilitate that witness once his credibility was destroyed. So, I mean, the defense did an excellent job in bringing out those points that would show his bias in his testimony, that he was the aggressor, and he was not, in fact, backing up and trying to, keep the peace, but he was being the aggressor, and Kyle Rittenhouse had no other choice but to shoot him. So excellent on the part of the defense.
Lawrence, there's no doubt. I mean, he sustained a horrific injury, right? Anthony Huber lost his life. Joseph Rosenbaum lost his life. He had his bicep was obliterated, and we see it in that gunshot. He's got a $10 million lawsuit, but the jury didn't find out about it until cross-examination.
Well, yeah, I mean, that's kind of ridiculous. They should have brought that out on the direct, and they should have talked about it. It would have lessened the blow. I mean, it's pretty shocking to hear that on cross. Oh, you have a lawsuit for $10 million. That's a bad job by the prosecution, Vinny.
Yeah, very problematic. Michael, I want to show you something here. This was another point where I was like, why is he answering this way? Talking about the gun and him pulling the gun out. Take a listen.
He tells you he's running, and he tells you, whatever he tells you, I'm going to the police, or what you think is, he pulled the gun first, and he's running away from you, right? He's running north on Sheridan Road. Yes?
Correct.
And he's running away from where you're standing. True?
Correct.
You, at that point, pull a firearm out from your belt and begin to chase him. True?
That is not true.
I want the picture. I'm going to show you what has been marked as Exhibit 35. Can you take a peek at that for a second? That's a picture of you, is that right?
On the right-hand side with the blue cap and... Yeah.
You can look there where
Yeah.
this is you, right?
Correct.
Okay.
Michael Bixson, he said no when he's asked the question. There's a picture of him, video of him going behind his back, grabbing the gun. I don't understand this. And I just feel like, and this is not necessarily the prosecutor's fault, but it ends up part of your case. This is your witness, your victim, your complaining witness, whatever we're going to call him in the courtroom. But he's saying one thing, and the video is telling me something else.
I don't know, Vinny. I mean, it's hard to say whether or not this really is or isn't the prosecutor's fault. I mean, I put a big part of it down to their preparation of their witness. And I think if they had spent more time preparing him and explaining to him that maybe not being combative to everything that he's being asked, maybe that's not going to put him in the best position, because it's clear. You look at the video, you see him chasing him, right? Or pulling out the firearm. These things you can see him clear as day. There's not much of an issue here. But when he starts lying or being combative with the, defense counsel, I definitely think you're going to start running into issues for the prosecution. And I definitely think they are because of it.
Lawrence, do you think he got advice from his civil attorney? And I don't know who his civil attorney is, but said, got to be careful. We can't say this. We can't say that. Because this is a complaining witness who hasn't really cooperated with investigators. He doesn't speak. He didn't speak with them. He didn't tell them his story. He didn't let them look at his phone. They wanted to take a look at his phone. He said no. He's acting more like a criminal defendant in his relationship with investigators here. And I'm not saying that he's a criminal, but that's the way he was acting, his reactions to everything. Not like your classic shooting victim.
Well, Vinny, I mean, isn't there the inherent problem in this case where you have all this lawlessness and all these different men running around with guns like it's the Wild West and it's just chaos? I mean, this guy has a gun. He's chasing after people, too. I mean, it's just nuts. I mean, I think everyone seems to have a gun here. Of course it's chaos. And is anyone shocked that people were actually killed by somebody this night? I mean, and to your question, though, I mean, yeah, I'm sure in his mind he's trying to be very careful in his answers. He's probably thinking through everything he says because he doesn't want to affect a potential $10 million windfall for getting his bicep blown off when he was chasing after somebody in Kenosha.
Yeah, and again, I'm not minimizing his injuries, and I'm not minimizing the death of Anthony Huber or Joseph Rosenbaum. The defense here is self-defense. So the defendant is saying he is the victim of all of this, and the jury has to figure it out. But right now, it is not a great spot that prosecutors are in. Can they still win it? Oh, maybe. When we come back, the think tank's with us the whole hour. But when we come back, we'll take a look at the redirect. Right after your witness gets cross-examined, you have an opportunity to put them back on or to question them again, to try to bolster their credibility and fill in the blanks, let them expand on some answers so you can regain the credibility of that witness and your case in front of the jury. We'll show you how that went next.
It was my interpretation throughout the events of August 25th that these armed individuals, whether they were Boogaloo Boys, Proud Boys, etc., all had we'll say a homogeneous appearance, again, meaning the rifles, the body armor, and what I had inferred throughout the events of that night, that these groups of people weren't received very friendly towards other demonstrators, and in specifically to reference the defendant, it was also my interpretation that the defendant lacked the necessary experience, potentially the necessary knowledge to adequately fulfill his self-proclaimed role as a medic.
The Boogaloo Boys, the Proud Boys, protesters. It was chaos. It was chaos in Kenosha, folks. That was part of the redirect of Gaige Grosskreutz. Let's take a look at another point of this redirect where he gets up from the witness stand and stands right in front of the jury to demonstrate what exactly he was doing. And it's interesting because we've seen it on video and we've got still pictures of it, but he's doing the demonstration anyway. And he's very comfortable. And he's got the microphone in his hand doing the demo. Let's see how it went and see if it made any difference.
Would you mind, if you can, standing up and demonstrating to the jury how your body is positioned in this still?
If the defendant is right here in front of me on the ground, this is my pistol that I had in my hand. This is my cell phone. My body is bladed towards the defendant. I have her cell phone in my left hand, microphone or pistol in my right. My body is bladed with my left hand, left arm, towards the defendant's firearm, with then my pistol in a similar angle I'm about to show you.
At that moment in time, right before you got shot by the defendant, did you feel there was an imminent danger that the defendant was going to kill you?
Yes, absolutely.
When you were just demonstrating to us the way your right hand was holding the gun, however it was angled, my question for you is that the way you hold and point a gun when you're going to shoot it?
No.
Okay, and he didn't fire the weapon. He didn't fire it. But he pointed it. So you've got two guys pointing guns at each other, right? I think they're both kind of in fear. I mean, everything he's explaining for Gaige Grosskreutz. I mean, Kyle Rittenhouse is in the same position at that moment as Grosskreutz is, right? They're both, it's a standoff. They both got guns. It happens very fast, but they're both pointing guns at one another. I'm sure they're both scared. Let's bring back in Court TV legal correspondent Chanley Painter, who is in Kenosha tonight. Am I reading that right? That at the moment that he's describing, they're kind of both in the same position at that one moment in time.
Yeah, I believe you are. And it was a poignant moment when Gaige Grosskreutz left the witness box and demonstrated him. He's directly in front of the jury at that point, demonstrating that positioning. And when he was asked, is that how you would hold the handgun to shoot it or point at someone? And he said, no. That clicked with the jury, Vinny. It did, and they wrote that down. And so it was a rehabilitation of this witness, and the prosecutor was able to make some of those strong points, including the fact as to why Gaige Grosskreutz would start running in the direction, not chasing, but running towards Kyle Rittenhouse. And that was made clear by the fact that he heard people calling for a medic, and he explained that's why he started running in that direction to try to help. And so again, some points made there, but every time a witness leaves that witness stand, that's a moment that any jury really will pay a lot of attention to.
Absolutely. And you know, will the jury make a distinction between this is not how I hold the gun when I fire it versus it's pointed in that direction, and should the defendant know that? Is it reasonable to think that he's in danger at that moment? That's their question that they have to answer. He also testified, though, didn't he testify that he made the decision to close in on Rittenhouse at a certain point?
He did. He made that decision. He said that was the moment. He had his hands up, put him down. That's when he described Kyle Rittenhouse re-racking the gun and what he perceived, Gaige perceived, as a malfunctioning of the weapon. And that's when he felt like, okay, this person's not accepting that I'm surrendering with my hands up. And he said that's when I decided to move in closer towards him to try to prevent myself from being shot with that weapon. And of course, at that moment, he was shot. So yeah, that's how he explained why he was moving closer to Kyle Rittenhouse. And you're right. It's what will this jury, is it what's in the mind of Gaige Grosskreutz or the mind of Kyle Rittenhouse here that they have to judge, Vinny?
Absolutely. Okay, let's bring back in the think tank. Michael Bixson, I want to ask you, will the jury make a distinction between this is not how I hold my gun when I'm about to shoot it versus it's pointed at the defendant? Is it a threat? Is it not a threat at that moment?
Vinny, it's on the video. I mean, it's clear as day. He's pointing the gun at him. I mean, you can take him and have him demonstrate to the jury how he was actually holding the gun and hold a microphone and sort of walk it through. But you can watch the video. You can see it clear as day. He's pointing the gun at him. I mean, I don't know how much more clear you can get, and you can try to rehabilitate him all you want as a witness, but there is no escaping that devastating cross-examination.
Casey, there are three counts here, right? Three, again, I keep wanting to say victims, but the judge isn't allowing that in the courtroom, but I'll use it here to say there's three shooting victims, right? Two lost their lives, and one who testified today was shot in the arm. So let's just deal with the one who was shot in his arm, Gaige Grosskreutz. At this point, is this a reasonable argument for self-defense?
It is and it isn't. I see both sides. I know that right now the jury is probably thinking, okay, That picture where the still frame of Mr. Grosskreutz pointing the gun, that is a reasonable explanation for self-defense. But at the same time, I can see the other side. The other argument is that he was going to shoot him, and Kyle Rittenhouse shot first and disabled that arm, which did not allow Mr. Grosskreutz to shoot back. Because if I saw that correctly, that arm that he shot his biceps, that was the same arm that was holding the gun. So he was unable to shoot. So at this point, it was who shot first, right? So had Mr. Grosskreutz shot Mr. Rittenhouse, he could have claimed self-defense as well. So it comes down to credibility. And again, his credibility was destroyed on cross-examination. Lawrence,
is this, I mean, under what scenario you have two people who don't know each other pointing guns at each other? At what point is it, under what circumstances would that not be self-defense? If there's two people who don't know each other that are pointing guns at each other?
No, I'm with you. I mean, listen, it's like if I walk into Walmart and there's a guy carrying AR-15, he's not pointing at me, but how do I react? I mean, there's been shootings in Walmart. Or is it self-defense if you shoot the guy? He's open carrying AR-15. You don't know the person's intent. And here again, you have all this lawlessness. Rittenhouse is on the ground, and there's gunfire going on. It's hard to really tell what's going on. For Rittenhouse doesn't know this guy's going to shoot him, and then I can't even pronounce his last name. I apologize. Is he worried Rittenhouse is going to shoot him? So to me, in this scenario, it looks like self-defense. I'm sure somebody will come back from the police and say, well, you really can't tell by pictures of what exactly he was doing because pictures don't tell a whole story, which cops say all the time in prosecutions to try to get around video. But clearly, if this guy's pointing a gun at Rittenhouse, whether it's directly at him, he's certainly close enough for Rittenhouse to be in fear for his life. So I guess maybe tie goes to the runner, and Rittenhouse is the one who's on trial, so he wins on that count.
All right.